Good afternoon. My name is Emily Harman. I'm the director of the Department of Navy's Office of Small Business Programs, and I'm here today with Mr. Elliot Branch, who is the Deputy Assistant Secretary of the Navy for Acquisition and Procurement, and Mr. Tom Frankfurt, who is the Assistant General Counsel for the Research, Development, and Acquisition, so ASN/RD&A. And we're here today to talk about two topics. One, the rulemaking process, and the other topic is government industry communications. So those are the kinds of questions that we'd like to get as we are live on Facebook. If you have questions that pertain to those two topics, feel free to send them in, and we'll do the best that we can to answer them. We have another Facebook Live session coming up with Mr. Branch later in the month that we'll advertise tomorrow, where we'll talk about other issues like category management, subcontracting, LPTA, and things like that. Today, we're just trying to stick to the rulemaking process and government industry communications. So if you could each give a little bit of your background, a little bit about the position that you hold and what you do.
Sure. Thanks, Emily. I've been an employee of the Department of the Navy for the last 35 out of 41 years. I am the Navy Senior Contracting Officer, and I have several responsibilities in that role. But the ones that are probably most of interest to our audience today is that I'm responsible for the Navy participation in the rulemaking process with respect to acquisition and procurement. I'm also the Competition Advocate General, and I essentially am the Senior Contracting Officer for the Department of the Navy.
What is Competition Advocate General?
So the Competition Advocate General is a statutory responsibility that comes out of Title 41 that came into being when the Competition and Contracting Act was passed. And my role is to essentially promote and to see that the enterprise promotes the use of competition, especially where it makes sense.
Okay.
So I tell people in my job as a competition advocate is to talk to anybody who wants to talk about Navy competition issues, whether they have an observation or a concern.
Okay, great. Mr. Frank.
I am Mr. Gertz's lawyer, RDA's lawyer. In my position, I'm the Senior Acquisition Attorney for the Department of the Navy. We have probably 400 acquisition attorneys overall. I lead a community of practice for those 400 attorneys across all commands, where we share practices and we have templates and share knowledge so that our advice to the Department of Navy is consistent, and it helps all of us jumpstart our responses so that we don't have to create everything out of whole cloth every time we have an issue. I too have been around for a while, been government attorney for about 34 years and 30 with the Navy. And I have started, it's been all acquisition with NAVFAC, NAVC, RDA, SPAY War. So like Elliot, I've been around the acquisition community my whole career. And it's a very good job. So if there are any attorneys listening, we want folks to strive for these type of positions, these leadership positions, because we need good people at the top.
So between the two of you, you've probably seen it all.
Well, I don't know that we've seen it all, but we've seen a good part of it, and I'm not sure the pieces we've seen we want to watch.
Okay. Well, my travels across the country speaking to small businesses, a couple of topics tend to keep coming up. The rulemaking process, especially when there's a law that Congress passed that everyone wants to hurry up and get with it and,
Sure.
and start implementing. Not so much if the law is, something that somebody doesn't really want to implement right away. So the one that's getting a lot of attention now is the Runway Extension Act, which says that for a small business, a business to count as small, we're going to count the average of the last 5 years of revenue instead of 3. And so the question is are we going to implement that now, or when would that be implemented, and what's the process?
Take a shot. I'll just take a shot at rulemaking in general.
Mm-hmm.
So rulemaking is governed don't glaze over. This will be short. Rulemaking is governed by the Administrative Procedures Act, and that really came out of the New Deal, where President Roosevelt was responding to the Great Depression, established several agencies, lots of regulations, and they were just put out there without any process at all from the public. So the Administrative Procedure Act was passed to give businesses and citizens impacted by the regulations due process, an opportunity to comment on the regulations so that they're fully vetted and the government fully understands the ramifications of them before they're actually passed. And for us, the Department of Defense, we have the ability, the authority to establish regulations based on our broad discretionary authority on all the statutes that are out there that govern the Department of Defense. And there's specifically mandated times from Congress where we have to pass regulations. So for example, when Secretary Kendall was ATL, he decided that in order to best comply with CICA and for the Department of Defense to get the biggest bang for their buck and to ever expand the industrial base, that he established this sources sought regulation, where every time you used one responsible source as your justification for sole source, that you had to put it out there for the public to see if anybody could possibly play in that particular area. So that's an example where we have broad discretionary authority. And an example where it's mandated by Congress is a case that's open right now for lowest price technically acceptable process, where Congress has come in and mandated that we rewrite the LPTA process, and the ramifications are that it's going to be a lot harder to use the LPTA process. If I could just go through the DAR Counsel, because this will address why it takes so long. I'm not really familiar with the FAR Counsel process, but just briefly.
So that's the Defense Acquisition Regulation?
Yeah, I think it's important to understand that all of this actually comes out of the Competition and Contracting Act, which also gave us a single government-wide regulation. So Tom's going to talk about the DAR process, which we control within the department, but the FAR is a system, right? So the FAR is government-wide, and then each agency has the right to issue its own regulation to implement or supplement to some degree what's in the FAR. So we do that within the Department of Defense in what we call the DAR Council, Defense Acquisition Regulation Council, and depending on the rule. So let's talk for a minute about the Runway rule. The Runway rule is actually probably going to be a FAR rule. Okay, because congressionally mandated, really levied on Small Business Administration. So they're going to issue a rule, and then we're going to implement that in the FAR or the DFAR. So that one is probably going to take us a little bit while to get to, and Tom's going to run you through that process because to use a kind of a current expression, it's a marathon. It's not a sprint.
Because that law that was passed, first, the Small Business Administration has to write a reg before we can even start taking it up and talking about putting it in the FAR.
Right. So the regs owned by Small Business Administration, owned by the Department of Labor, and other agencies that have cognizance over this, are in the FAR really as a convenience. And what we do in the FAR and in the what's called the DFAR, the DoD Federal Acquisition Regulation Supplement, is we place those rules in there, and then we write any implementing guidance for the rules written by Small Business or DOL to make sure they work within the Department of Defense and the Department of Navy. So Tom, you want to talk a little bit about that marathon?
Sure. And just a foot stomp what you both said, that small business rule has to go through the small business process. And most likely a rule like that the FAR will probably just adopt the SBA determination, whichever comes out in the 13 CFR. But it's a deliberate process so that everyone gets to participate and we get the rule right. So for the DAR Council, for example, we'll have a piece of legislation that's passed. The DAR Council will meet. DAR Council is made up of representatives from the Air Force, the Army, the Navy, and DoD. It's chaired by Linda Nielsen, and it reports to Director of Pricing and Contracting within OSD. So they get the statute, for example, and then they meet as a plenary session as a full council. Most if not all the times, they decide we're going to open up a case.
Mm-hmm.
So they'll assign a case number to it. Then they'll assign it to a team, like procurement integrity or financing and payments, etc. And then the team will start to draft the regulation. And at some point, and that takes a while because there's back and forth, there's coordination not only with the team members, but with their principals,
Yeah.
right? And that back and forth goes on for a while. And then at some point, the team will draft a Federal Register notice.
Mm-hmm.
The Federal Register notice is required by the Administrative Procedures Act. It actually goes in the Federal Register for a notice and comment by the public. But this is a draft Federal Register notice that then is delivered to the full DAR Council. And at some point, the team pitches it, briefs it to the DAR Council.
Okay.
If everyone agrees with the Federal Register notice as drafted, it then moves to the Office of Management and Budget, which is looks at it from a Paperwork Reduction Act point of view to make sure there are no additional documentation requirements put upon the public. And if it's approved by OMB will put it in the Federal Register.
Okay.
And at that point, we use between 30 and 90 days for the public to comment. And we also allow replies to the public comments so that Lockheed has an example, comment for example, Raytheon could reply to
Okay.
the Lockheed comment. We then gather all those comments. This is why it takes so long. We then gather all those comments and then we synthesize them and summarize them. And if they haven't opened new doors for us that we think we need to go back out, we will summarize those comments and then we'll draft the final rule with those comments summarized. And then it will go back up to OMB to issue it as a final rule. Sometimes we have hearings, not very often. Sometimes we allow ex parte presentations. Again, not very often, but our door is open. And the whole point of this is to make sure the public sees all the comments that come in. They're part of the process so that the rule is issued fairly and transparently and all concerns are adjudicated.
So if I'm a member of the public, I'm a small business and, I don't like the way maybe the FAR or the DFAR Council is implementing a reg. Is it really worth my time to comment? Is my comment going to get read?
Absolutely, it's going to get read because we have an obligation to disposition all comments. Even if it's to come back and say we read it, we don't agree with you, and here's why we don't agree with you. We have to respond to all comments as a class. And the other thing that I want to emphasize here, as we talk about acquisition reform and we talk about the complexity of the regulation. This is why those clauses and provisions are actually so critical to the process. Because as you listen to Tom, there are all the stakeholders within the government consider all the issues that need to be considered. Then we put it out so that the public can comment on all the issues that need to be considered. And we have an opportunity, really an obligation to respond to all those comments, in a very, very transparent way. So by the time we get to a final rule, we've vetted it across the stakeholders. And what this does is while people will argue that it constrains flexibility, it does put some certainty into the marketplace. When industry approaches us, they can read that clause and they can assess their risk of performance. They can assess their risk with respect to price, and they can decide whether to bid or not. This would be better, in my view, than a company trying to sell to the Department of Veterans Affairs and having one provision that deals with termination, and then coming into DOD and having to deal with yet another provision that deals with termination, then going with Homeland Security and dealing with yet a third. So I'll call this speech defensive boilerplate, but I think it really does serve a purpose in actually streamlining the system.
So that's a reason that DOD doesn't get out ahead of everyone else and go ahead and implement it, because we might implement it differently. But then there's a case where on the limitations on subcontracting, the similarly situated entities rule, where DOD did go and issue an interim rule.
Yes.
And so what's the thought behind that? Do you know? I mean, how do they decide if they're going to issue something interim before it actually gets in the...
Well, if you look at where a lot of procurement regulation comes from, or requirements for procurement regulation comes from, especially legislative requirement, it really kind of falls into three categories. So number one, there are provisions in what we call the National Defense Authorization Act that are very plain on their face. There are very specific instructions as to what the agency is to do. That probably doesn't require rulemaking at all. And then there are cases where at the other extreme, the Congress says within so many days, the Secretary of Defense or the Administrator of the Office of Federal Procurement Policy shall, issue regulations to do X. And then there's this kind of middle ground, and this is, the cyber rules are a really good example of that, where we look at it and say, well, there's nobody telling us, to implement this. But given the impact this will have on industry, it really does need to be subject to a rulemaking. All the stakeholders need to be heard, and we need to issue that in a uniform way.
Okay.
That's a good point, Emily. We have, and Elliot could do this sometimes, and mostly it's done at the DOD level. We can issue deviations and sometimes class deviations, like the micro purchase threshold. When that's raised to $10,000, we'll get that out right away. Normally, these things are not these statutes or other areas where we issue deviations. They're non-controversial.
Right.
So raising a micro purchase threshold. Another example is where industry would want this, and they did want it.
Current cost and pricing.
Current cost and pricing data.
Yeah.
And last year we had they changed the notice period for protests. So, for example, it used to be 5 days after debriefing, or 10 days after award, whichever was later, and that would change to now the offerors, unsuccessful offerors, I guess a successful offeror can come in and ask questions after the debriefing. They have 2 days, and then we're required, although I guess it's not statutory foul, to respond within 5 days of their new questions. And then they have another 5 days to protest. So we put that out as a deviation. That'll ultimately get into the to the DFARs and the FAR.
Okay.
But since that's, like Elliot said, that's plain on its face.
Right.
Another example was actually this is one we pushed through as a DAR provision very quickly. We essentially copied the statute, and it was because we couldn't obligate any funds under the contract unless the contractors agreed to this clause, and that was the anti-human trafficking clause, for example. No fund shall be obligated until the contractor certifies that he has a compliance plan in place not to engage in slavery or even for the subcontractors it flows down. So that went out quickly, and basically the DAR Council copied what was in the statute and put it in as a DFARS clause.
Okay. All right. Well, thank you very much. I think that helps answer why things take a little bit of time and why we are deliberate and think through regulations before we issue them. And hopefully that will answer a lot of the audience's questions. I don't have any questions that have come in on that necessarily. So let's skip to government industry communications. There have been several myth-busting memos that the Office of Federal Procurement Policy has issued to try to help bust the myths about when government employees can talk to industry and vice versa. And back in March of 2008, then DepSecDef sent out a memo as well to the workforce talking about how our national defense strategy directs our intentional engagement with industry to harness and protect the national innovation base. Yet, you know, on my travels, and I think your all's too, you hear people feel like they can't talk to industry or having questions about when they can talk to industry. So just wanted to talk about that a little bit and see what you say about, you know, what kinds of information are you passing on to your contracting officers and to your attorneys about government industry communications?
Yeah, I'll start that off. So number one, government and industry can always talk. Okay, so let's make that clear. Government and industry can always talk, full stop. Now, depending on where we are in a particular stage of procurement, that conversation may be constrained. So for example, once we've issued an RFP, that communication should be only through the contracting officer or, you know, people that the contracting officer designates. But program managers and other people always have the right to talk to industry. As a matter of fact, it's encouraged. It's called market research. You know, how do you understand, you know, the way you want to articulate a requirement unless you know how industry is organized to settle or to supply that requirement,
right,
supply a solution to that requirement. So we go out and tell our workforces, you need to talk to industry. As a matter of fact, talking to industry will make your job easier in the long run because it will help you to develop an informed requirement. So we get that word out. I know Tom gets it out to his attorneys. I talk to my contracting officers and make it clear they understand that. And going back to one of your initial questions, what's my role as a competition advocate general? I don't want to be the complaint department across the enterprise, but if we have a significant barrier to communication, I mean, if you are just so frustrated that you feel like you need to seek relief, that's what my office is for. And we've got, you know, various ways of contacting us. We, you know, email, and I've got a team of people who look at, you know, the issues you're raising, and we go back and we do the research with those organizations and we try to find resolution.
Yeah, my main goal out of this Facebook Live is don't be blaming the attorneys for folks not communicating with industry. And to the extent the attorneys are getting in the way, my number is 703-697-5213. So, I mean, the idea that we would frustrate any conversations before an RFP is issued is ludicrous. I mean, like Elliot said, we need industry to help us define our requirements. And there's no issues there at that point except trade secrets. You know, you're not going to give up proprietary information on another vendor. Freedom from Information Act requirements. You don't really have procurement integrity because the RFP hasn't been issued. So it's full and open conversations before the RFP is issued. When the draft RFP goes out, I'm pretty much on board with, it's almost the same as no RFP has been issued. I would like folks to at least include the contracting officer, maybe not at every meeting that program or technical people meet with, but inform them at some point that you had this meeting, so that contracting officer will have full knowledge of the requirement and helping draft the RFP going forward. It's best if you could have the person, the contracting officer there, but that's not mandatory. But once the RFP is issued, the contracting officer becomes a focal point. So the contracting officer should be involved, and if not all the meetings, most of the meetings, so that you know, so that the process of equal playing field is protected. Elliot and I are going to right now. We're going to talk about one-on-one meetings. One-on-one meetings. Are those okay? Yes. they're okay.
Absolutely.
Why don't you go first on one-on-one?
Well, absolutely, they're okay. It allows for a franker exchange of views. What we can't do in a one-on-one meeting is we can't give information to a single party that we're not willing to share with everyone else. Outside of that particular restriction, there's no reason we can't hold one-on-one meetings. Now, I will give you, call this a mentoring moment to the contractors out there. My experience as a contracting officer tells me that some of the reluctance to talk to folks is that people go, well, if I talk to one guy, I've got to talk to everybody, and I really don't have time to talk to everybody. And I make a couple of observations. Number one, that is actually not true. Okay, I don't have to stand on the street corner and seek a conversation with everybody who could potentially bid on a particular requirement. What I do have to do is I've got to open the door and let somebody have a conversation with me if they choose to have a conversation, which leads me to the second point. So industry, if you've got something that's value added to say to a contracting officer, that's the time to hold a conversation. If you're really just kind of trying to get some advance information on what may be in the RFP, or you're trying to plant a seed in the customer's mind as to what solution may be better than another solution, that's not helpful. Mm-hmm. But if you're looking at our requirement and saying, the market can't provide that, or I've got a unique way to provide that, and I want to share with you what you need to do to that requirement to broaden the competitive base, we welcome that kind of conversation. So I think if industry really comes in and gives us value-added feedback on draft RFPs and on requirements that they have visibility into, contracting officers and program managers will become less reluctant to talk to industry because they'll see something for themselves. So just ask yourself, is what I'm going to offer up value added to the government? Will it help the government in crafting a requirement that's really going to give capability to the warfighter, lower cost, increase speed, or do something that's going to benefit the taxpayer?
That's a really good point, because I remember when I was a contracting officer, sometimes people wanted to meet with me and then they'd want to know, well, when's the RFP going to come out? Well, I'm not going to tell that one company when the RFP is going to come out. Yeah. I would say you've got to keep an eye out when you will know when everyone else knows when the RFP is going to come out. So I think that's good that the industry has to have a good intention behind why they want to communicate.
Yeah, and we have adjusted, RFPs. I won't go into specifics, but there are a couple of really large recompetes that we did a few years back, where industry had some concerns about the potential competitive advantage the incumbent had. Mm-hmm. And because they came in and expressed that and helped us to really understand their concerns, I think we did some pretty novel stuff in that particular RFP that allowed us to increase the competitive field. We think that was a success story.
Yeah, for the government, we're seeking to be impartial at all times. So obviously it depends on the procurement. If there's a procurement out there where we have 100 or more vendors that can compete for the work, it's going to be difficult to accommodate all the vendors, even when they request the meeting, especially if it's going to address an issue that we've already heard a couple of times. But if it's a large weapon systems procurement and there's, say, 4 vendors that are competing for it, if we hear from one and the other 3 ask, that's a situation where we have to accommodate them and bring them in. So here's one too. What about after receipt of proposals? Okay, now we're in the source selection. Should we be talking to industry? Well, we wouldn't be talking to folks outside the source selection, outside the offer wars necessarily. But the offer wars, if they believe that even after and they didn't protest it, but they believe that the RFP is still restrictive and they'd like to expand it to make themselves and the other offerors more competitive, that looks like it's more tailored for one of the vendors. We should hear that. We shouldn't close that off. We should hear it. We don't necessarily have to amend our RFP, but we should at least hear it. And again, I would like the contracting officer to lead that. A lot of times, especially if it's one of the huge procurements, they like to go to the CEOs of those companies, and the business leaders of those companies like to go to the Secretary of the Navy or Assistant Secretary for Research, Development, Acquisition. But my preference is, okay, that can happen, but the contracting officer should be there too. Because the contracting officer ultimately is responsible for the procurement. But my point in all that is that it's okay even then, although that's much more closely structured because we're worried about unequal discussions or improper discussions.
Mm-hmm. So can government employees, as part of their market research, visit a company's facility and
Absolutely.
take a look at that?
Absolutely.
Okay. No problems with that. So what if one common misperception is that agencies have kind of already determined who they want to get the contract. And so when they release an RFP and they only give a few days to respond, or if the language in the RFP looks a little restrictive, it sounds like you all both feel that the industry should speak up. Companies should speak up about that. They're not going to get blacklisted by saying that.
No, they absolutely should speak up about that. And I don't think most program offices or their contracting officers act in bad faith.
No.
Okay.
I agree.
I think in many cases they act in what economists call bounded rationality, right? Which means I only know what I know. So, I draft a specification or a statement of work that may be restrictive because I really don't know any other way to approach this, which is why industry dialogue is so important during the market research phase. Time may really be an issue driven by the urgency of the requirement. Now, I will observe that in many cases that's not urgency within the meaning of the FAR or the DFARs, but sometimes priorities, and I'll just ask you to run a thought experiment here. So we've had a 35-day government shutdown in our civilian agencies. That's 35 days when procurement packages didn't move.
Right.
So everybody's now got to come back to work. They've got to spool back up, and they may lose as much as, say, 2 months on doing a procurement. So suddenly, and I'll give you a hypothetical example of that, and I want to make it clear that it's hypothetical. But think about some of our airports where the TSA stations are operated by contractors. Mm-hmm. So to the extent that we were lead time away, perhaps, from putting renewal contracts in place, now it is urgent, right? And we have to move fast. So there are a lot of reasons that we have to move fast that are not always apparent to the vendor community, but they are reasons that kind of stem from good faith.
Right. So it's something that we do think about that. We don't just blindly put out a RFP and give you 10 days to respond. We think about the amount of time.
Or the money doesn't arrive.
Right. Right.
That's another big, with all the CRs, kill us, because when the money doesn't show up until late in the year, then we're under either pressure to get it obligated or pressure to meet operational, timelines.
Right. Okay.
Yeah, I would agree with that the contractors should, if they're not getting satisfactory answers at the local level, they should raise it up. Not to raise it up so we sole source to the contractor who's complaining, but they should raise it up if they feel that it's structured in a way that only one contractor can win. And we at Elliot and my level, we look at these things all the time with the assistant secretaries. So I would encourage folks to raise it up the level of the government. I got one more before we leave. Mm-hmm. And this is for contractors and contracting officers and lawyers and technical folks. On the performance side, where things aren't working out smoothly and the contractor believes that there's work that's being asked for the contract to do that's not covered by the contract. And there's discussions about equitable adjustment and ultimately a claim. I would encourage both the government and the contractor to have discussions about that issue early on. I think we do that for the most part, but there are times where we don't, and I don't know if for folks on the government side are worried about jeopardizing the case in litigation. It's not criminal law. It's business transactions.
Sure.
We're trying to get to the right answer. And if we're at fault, or even if the contractor's position needs to be enlightened by additional facts from the government, that back and forth will help us get to a resolution of the dispute, rather than having that thing fester throughout the performance of the contract. So I would encourage in the performance side that we have the same open communications that we do on the award side.
Right. And if you're a contractor and you're finding that you're having some challenges with performing, don't hide it. Talk about it. Bring it to the government's
Absolutely.
attention. There might be something that we can do to resolve it in easier than if we wait.
Right. Litigation is a resolution, but not necessarily the one we want. Right. We're trying to get capability to warfighters. And if we can get capability to warfighters by having a conversation and working things out within the construct of the contract, we'd rather do that than to have a conversation in front of a referee.
Right. So some of the questions that have come in, I'm going to save them for the next Facebook Live that I have with Mr. Branch in February, because they're not really necessarily along the topic that we're discussing. But I wanted to talk a little bit about debriefings. Is it important for a company that wins to come in and get a debriefing, or should you only get a debriefing if you lose? And what kinds of things do we share at debriefings? Why are they a good thing to attend?
Well, I'll start. So now that question is somewhat moot, because companies, whether there's a successful offer or unsuccessful offer, are entitled to debriefings. Mm-hmm. But let me talk about why somebody might want to debrief from my industry, my time in industry. When we looked at RFPs in my company, we would look at Section L and we would look at Section M, and we would develop what I would call a decathlon strategy. So if you have, say, 10 evaluation criteria, not that anybody uses that many, but just kind of consistent with the model, you might look at that and you might say, I'm very, very strong in management. I'm not nearly as strong in corporate experience. I might not be, but I'm absolutely superior in terms of my ability to build a staff. So the strategy might be like somebody running a pentathlon or a decathlon, where what you're trying to do is you're trying to distance yourself from your competitors in terms of your strength, and you're trying to minimize the distance from your competitors in terms of your weaknesses. Mm-hmm. So a successful offeror might want to come in and get some feedback on how well he did in that strategy. And of course, if you're an unsuccessful offeror, you want to get some sense of, hey, what can I do better the next time? So I think there's some value in debriefings for both winners and losers, because whether you use my model of decathlon or whether you use some other model, everybody who's trying to do capture work has a win strategy. Mm-hmm. So that debriefing provides you some feedback as to how good your win strategy operated in this particular instance, and gives you an opportunity to learn.
Good advice.
Yeah, from my perspective, if the unsuccessful offeror brings a lawyer, that's okay. That shouldn't chill our conversation. My position is we get these right 99% of the time, and we should share the good work that we did in treating the offeror fairly and consistent with the evaluation criteria. So I'd like us to give as much information as we can. Obviously, we can't get point by point and give the successful offeror's proposal. The unsuccessful offeror's proposal, we should be able to work with them until they're fully informed through the debriefing. At some point, we can't satisfy everybody, but at least that they feel that they've been fully informed by us as far as we can go. And don't let the fact that they're bringing a lawyer chill the conversation. And then by being open, that might help the lawyer persuade the client that this one's not worth fighting about.
Mm-hmm. So in sources sought, when this is before we even issue the RFP, I'm back to before we issue the RFP, we issue a sources sought, and that's part of our way of doing market research, finding out if there's companies out there that can satisfy our requirements. And when we, in those cases, I think there's times when industry would want a debriefing, and or at least may not be called a debriefing, but wants to know, well, how come you decided to go full and open, or why didn't you go service disabled, better known, set aside? How much? What do you think about communications there?
Well, I mean, certainly, we should give feedback to people who go through the trouble of putting together a statement of capabilities. Because again, we want them in our industrial base, and they need to know what they need to do to get better. I talk to a lot of small businesses, who are just trying to understand how to get into the Navy marketplace, because we're organized very differently from, the Air Force and the Army. And so often they walk into my office with a formula, if you will, and I want to put the word formula in quotes because there's no value, attached to that. But they have a business model. They've made it successful. Maybe it's successful, in the Army, and they expect that they ought to be able to bring that same business model and be successful in the Navy. Well, not necessarily, because if you look at the Army is a highly centralized contracting organization. They have what we call 4 heads of contracting activities, whereas in the Navy we have, including my office, we have 11 heads of contracting activities. So the amount of shoe leather you have to exert in the Department of the Navy may be very different from the amount that you have to exert in the Department of the Army.
Right.
And you have to understand that we're kind of organized by product lines, and that we have rules about how our contracting office runs. Generally, the way I like to think of it is you buy for mission. So if you are the Naval Air Systems Command, you buy all the aviation stuff, and you buy for your own account. So you buy for those activities that you need to sustain the organization. And we've got 10 of those. So we're organized very differently. And I think, people often kind of shotgun in a statement of capabilities thinking, well, it worked at the Army, it worked at Coast Guard. So why isn't the Navy accepting that? When you gotta, the bottom line is you gotta do your homework. You gotta know who you're trying to sell to.
And we have a whole video on that too.
Yeah.
So yes, that's definitely true. Any thoughts on that?
I think I covered that pretty well.
Okay. I just have one more question, and then we can wrap it up unless there's other questions that have come over on the computer, and that is industry days. What guidance do you give to contracting officers, attorneys about the importance of industry day? How do we decide when to have an industry day? And is it really worth it for companies to attend? And another question I have, which is probably putting you on the spot, but could we do industry days where we maybe record them and share them like we're doing this, instead of requiring companies to come and be at our site? Would we reach a broader audience if we were able to record them and share it that way?
I don't know
Lots
of any
of questions.
prohibition that would keep us from providing an industry day with this type of media forum.
Okay.
Unless I'm missing something that came out recently. And so that, to me, that would be a good idea. The problem with the industry days, and you hear this from industry, is that, and you see it when we have them, the industry is reluctant to ask a lot of questions that are maybe particular to their solution for fear of being put at a competitive disadvantage.
Mm-hmm.
I don't know how to get around that.
Mm-hmm.
Certainly we can offer, like we do, if companies have further questions or if they want to meet with us later, feel free. But we do really want these industry days to be much more give and take. And from what I understand, the IT ones are because there's a lot of COTS solutions out there, and there is a lot more give and take on this. But for these proprietary systems, it seems to be stilted by the audience as opposed to the government. I think we're there, trying to let folks know, here's our requirement. What can you bring to the table to help us shape the requirement in a way that reaches the most amount of potential competitors?
Right. Okay.
So I think people need to understand that industry days are just one tool in the toolbox, right? And this comes to, I think, for a lot of companies, where do you want to put your bid proposal dollars, right? So, draft RFPs, right? We'll issue in many cases, especially on larger programs, several iterations of draft RFPs, industry days, technical libraries, because we will often set up a technical library so people can look at documents that are relevant to the requirement. And we'll often offer one-on-ones. So not every industry day is created equal, because not every program manager has decided to use those four basic tools in the same way. And so the message that I would give is don't expect the industry day to be kind of the definitive event that gives you the information you need to bid a requirement. You've got to look at the requirement and you've got to say, hey, do I have enough of a stake in this? Do I have enough interest in this? Can I put together a good enough team to really have a chance at winning this? And then you've got to commit to the shot. You're in or you're out. So you got to commit to doing the RFP reviews and giving feedback to the government. When we have them in draft, you've really got to go into the technical library and try to mine that for as much as you can. You've got to take advantage of the one-on-ones, and of course you have to go to the industry days. So my counsel to everyone, government and industry alike, is don't think the industry day is kind of the central event around which the acquisition process is going to be created. It is but one tool in the toolbox.
Right.
And I would encourage, and I think this happens, sometimes it doesn't, that the government makes a concerted effort to have a back and forth with industry at the industry day. That we don't just say, here's our requirement, draft RFP is coming out on this date. That when we get the questions that address issues that we hadn't thought about for a requirement, for example, that's okay, especially technical folks at the industry, to talk about that and how we maybe hadn't thought about it, but that's something we should think about maybe working into the requirement. And not be concerned that if they say something like that, that somehow jeopardizes the procurement going forward. This is the perfect time to have a full and frank discussion before we start to solidify requirements in writing.
So we can get it right.
Right.
Okay. Well, before I wrap up, do either of you have any closing words that you want to say? Anything you want to say?
Well, Ellie, first of all, I appreciate you asking us to come over and talk about this stuff, because I think this comes back to a central theme that Tom and I have been talking about this afternoon, which is this is all about communication. This is all about keeping the lines of communication open and having frank and productive conversations about how industry can partner with the government to provide capability to the warfighter at an affordable price that allows industry to make a reasonable return on their investment. So thanks for asking us over this afternoon.
Sure, thank you.
Yeah. One more point on rulemaking. We get the requirement from Congress, like the Authorization Act. We do it on our own based on issues that we see popping up over and over again. But industry can bring it up to us too. There's websites all over DoD for acquisition where these types of issues can be brought forward. And I would encourage folks, if they see a better way of doing business, to put forth an idea where a regulation might be modified or limited. And so I would encourage that. And yes, Emily, thank you very much for this. I enjoyed my first Facebook Live,
Well, you made me think of one question, Tom.
Sure.
And this is something I've been seeing a lot of communication on LinkedIn, because the Section 809 panel just came out with its third report. And so there's some recommendations in there that pertain to small business. So I've seen on LinkedIn some companies being concerned about, what the recommendations were. My recommendation to those companies, this is what my thought process is. This is a report that Congress commissioned. It's a report to Congress. Congress asked, how can we do acquisition better? The commission is, the 809 panel was telling them that. Congress has to then decide what they want to implement and how they want to implement it. There'll be hearings, I'm sure, or, some discussion. There's opportunities for folks to, for industry to voice their opinion. And then if a law comes out, then we have to put it in the regs, and we'll go through the rulemaking process.
Yeah,
and so,
absolutely.
but this is like the 809 panel is kind of the beginning of a rule of starting a rulemaking process.
Yeah,
so,
but I do want to say, because I was involved in that, is that we did a lot of outreach to all the stakeholders, including small business. So small business has been with us, from the beginning, and like the rulemaking process, right? We don't necessarily always agree,
right? But
we try to be as transparent as possible,
right?
So,
right.
And there will probably be opportunities, as the spring comes, to give us feedback on how we did. As a matter of fact, we've got one of those next week at Covington and Burling. I think it's probably fully subscribed. It's an NBIA event, but we'll be down in Jacksonville at the end of February, talking to our own folks at the Services Acquisition Council. So various 809 commissioners will be out and listening,
right?
For that feedback. And that's especially true of General Mike Hoskins, General Cameron Holt, who's Air Force, and myself, who will likely be on the receiving end of some of our own recommendations. I like to think of it as having to eat my own cooking.
Okay. Well, thank you very much, gentlemen, for participating. So as I close out, I just want to highlight a couple of things. The next Facebook Live is going to be with me and Mr. Branch, and it's going to be on the 19th of February from 3 to 4. We'll be discussing event topics such as acquisition cycle time, how long it takes to get acquisitions in place, contracts awarded, low price technically acceptable, category management, subcontracting, just to name a few. And I've got the questions that were submitted to me here that we'll make sure we answer as well. We have a couple of big events coming up. One is Sea Space. We'll be posting about it on our Facebook and Twitter and LinkedIn accounts. But Sea Space is an event where we'll have some interaction with small businesses, as well as our Department of Navy Gold Coast, which this year is in July in San Diego, and Sea Space is in the first week of May. And we also started a LinkedIn page, which we'll post about that on our Facebook site as well. We will post this video on our YouTube channel, and then also a link to it from our LinkedIn page. So we're trying to get out there and communicate with as many companies as we can. I know not everybody likes to be on Facebook, so that's why we started LinkedIn. So hope that you interact with us. You can rate us on our Facebook page. Tell us what you think. How did we do? Tell us how we can improve and how we can communicate with you better. Thank you, everybody, for listening. Bye. How do I hit? I always like that. Okay. Thank you all.